You're live on the Joy News channel here. My name is Daniel Dazi. It's day 21 of the election petition that John Dramani Mahama has brought, seeking for a rerun of the 2020 elections. We will take you live to the courtroom now, where the 7 justices of the Supreme Court who are presiding over this case have taken their seats. Let's go then.
May it please.
Please, may you have my attention? May I have your attention? Please, where is your counsel?
Where is your counsel?
At the registry. Yes, please announce yourself.
May it please my lords, Justin Amenuvo appears for the first respondent with me, Somoa Asamoah.
Yes. Yes.
If it pleases your lordships, Akoto for the second respondent. My lords, with me are my learned colleagues, Frank Davis, Kweku Esrefi, and Yao Opong.
My lords, I apologize for being late. My learned junior is also on his way. We were trying to ensure that we complied with your orders yesterday. We have just succeeded in filing a memorandum of issues. We are also in the process of filing an application for review of your ruling yesterday.
Mr. Chikata.
Yes, my lord.
Yes, we want to have copies and consider it, so we will rise and come back.
Very well.
For the issues.
That is correct.
Yes, okay.
All right.
You're live on the Joy News channel. What we just witnessed was an introduction of the various legal counsel for the parties involved. Johnson Esiedun Ketia, General Mosquito, General Secretary of the NDC, is representing John Dramani Mahama in court today as the petitioner. His lawyer, Chachuchi Kata, was a few minutes late. He entered, you just heard him apologize. He said that a memorandum of issues was just filed in pursuance of the court's orders yesterday. This means that these are the issues that will be discussed during the case management or pre-trial, which is set to begin today. Also, he mentioned that they're in the process of filing an application for a review of the ruling which was given by the court yesterday. Now, that ruling was the dismissal of his application for interrogatories. What those interrogatories are simply a set of questions which are written down, of course, that his side, Chachuchi Kata, has submitted for the Electoral Commission and President Akufo-Addo to answer. Of course, most of those questions are directed as the chairperson of the Electoral Commission, Jean Adequoy-Mensah. And what the judges of the Supreme Court said was that they want to have copies of this memorandum of issues, and I'm sure the application for the review, so that they can review it as part of today's procedure. And so they have decided to rise. The persons you see in your shots now are the legal team for former President Mahama. I see in the shot Chachu Chikata on the far right. Two persons from him is Abraham Amaliba, who is a member of the legal team. I see Eduji Tamaklo there as well. Eduji Tamaklo currently on your far left. I see Baba Jamal standing just behind Abraham Amaliba at a point. I also saw Joyce Bawa Mokhtari, former Deputy Minister of Transport, who is also a spokesperson for former President John Dramani Mahama. She was wearing a black and spotted face mask. That she was right behind Eduji Baba Jamal, I must say. So it looks like it's a different day. First difference that you must recognize, of course, is that John Dramani Mahama himself is not in court. He's being represented by Johnson Esiedun Ketia. You heard there the justices of the court ask him where his legal counsel or his lawyers representing him are, and he said they're on their way. Chachuchi Kata entered a few minutes later and said that he was trying to go by the court's ruling yesterday. Remember, yesterday, when the court adjourned, Chachu was requesting that the issues, the consideration of the issues is done on Thursday. It was his request that the case management and pretrial, which is what we are beginning now, was done on Thursday, because according to him, they wanted a certified true copy of the ruling on his application for interrogatories and advise themselves. Later, our court correspondent Joseph Akable spoke to Dominic Ayine and said that does it mean that the content of that ruling by the justices of the Supreme Court could affect the case going forward? Dominic Ayine answered in the affirmative. He said that yes, indeed, that ruling would affect how they deal with the case going forward. We now know that they have applied for a review of the ruling. The lawyers educate us that, of course, what this means is that they would want the court to reconsider their decision to dismiss the application for interrogatories. Like we said earlier, these interrogatories are simply 12 questions that they filed, that they asked that the Electoral Commission answer. Key among those questions is whether or not the National Communications Authority aided in the transmission of the election results from December 7 through to December 9. And so those are some of the questions that will be dealt with. We also know that yesterday there were some facts that they filed, and they are also, it's sort of a request for facts really that they set out, 19 of them. Mr. Chikata mentioned that these are not exactly documents that they're tendering in, that they are presenting in the form of a motion or an application to the court, but those are some facts that they are requesting for. So that's what we know so far. Of course, we also saw the introduction of the legal team for the Electoral Commission, which is the first respondent, led by Justin Amenuvo. There was also Akoto Ampao, representing President Akufo-Addo, Frank Davis, Kwekwe Silfi, and Yaopong forming his legal team. So the court has risen, the justices have risen. They are currently waiting for the documents that Mr. Chikata filed, which are the memorandum of issues being filed, and also the application for a review of their ruling from yesterday, which they will be able to consider when, of course, the court resumes sitting. Today is day 21 of the election petition. What that means is that it's been 21 days since President Akufo-Addo and the Electoral Commission received the election petition that John Mahama filed at the Supreme Court. So John Mahama filed the election petition on the 30th of December, 22 days ago, but the lawyers educate us that indeed the counting of days begins from when the person is served, when President Akufo-Addo was actually served with these documents. And so today is day 22 of this particular court case. I'm going to quickly run you through what has been achieved so far. This began with the petitioner filing his petition. On the 8th of January, the petitioner, John Dramani Mahama, and his legal team filed the motion to amend their petition because, as was widely published, that petition contained some mistakes. For instance, the first respondent is the Electoral Commission. The second respondent is President Akufo-Addo. There was a time when they referred to President Akufo-Addo as the first respondent, which then meant that Mr. Mahama wanted a rerun of the election between himself and the Electoral Commission, which was not possible. So some of those mistakes have been corrected. On the 9th of January, the respondents, being the Electoral Commission and President Akufo-Addo, filed their answers. On the 14th of January, there was a motion to amend which was granted. That motion that former President Mahama filed on the 8th of January to amend his petition, which he filed on the 30th of December 2020. That motion was granted by the Supreme Court after some opposition, of course, from opposing counsel. On the 14th of January, the 15th of January 2021 was the deadline for respondents to respond to the amendment. The 19th of January, the Supreme Court denied leave for the petitioner to serve interrogatories. That was yesterday. And the parties were to file their issues by 9:30 a.m. today on day 21. So those issues are the issues that were being filed by Mr. Chachu Chikata, which is what detained him slightly while he entered the courtroom late. Of course, today, the 20th of January, is when the pretrial hearings are to begin. These pretrial hearings, we are educated by the lawyers, will simply be an opportunity to do three key things. And I'll quickly run you through these three things. The first thing is that both sides or both parties will lay out clearly the issues or the questions that they want addressed. What does this mean? John Dramani Mahama is challenging the election petition for a reason. He is challenging the election result, for a reason. There are specific questions that are bothering him, which he wants clarification for. Throughout the entire court process, his lawyers will be advancing that argument. They'll be asking specific questions to unearth those facts which he wants clarity on. Now, it will be necessary for his lawyers to state those facts clearly during the pretrial hearing, so that during the questioning of the witnesses and what have you, the judges can pay attention to those specific issues. So the judges will have in the back of their minds, oh, this is why they're asking this question. But does this question actually reveal the facts or reveal the issues that John Dramani Mahama and the election petitioner, the election petition legal team is really pushing forward? Of course, President Akufo-Addo and the Electoral Commission also have their issues that they want the court to narrow down on. And so they are also filing those issues so that the court can follow their arguments in a coherent manner. Also, another interesting part of what will happen during the pretrial hearing is that everything the witness wants to tell the court, the witness statements, will be written down. So instead of going like what we saw during the 2013 election petition, and you had Mr. Baumia, then vice presidential candidate, then lead petitioner, going through pink sheets with his lawyers. This time, the witness statements, everything that whether it is John Dramani Mahama or any of his 5 witnesses want to say when they get on the stand, everything is typed out. So what would happen is that we understand his lawyers will simply go to him during the hearing. They'll ask him, is this your statement? Do you agree that this is your statement? And then the cross-examination can continue. All of this is part of the process, the lawyers tell us, which would really simplify the court proceedings and make it very expeditious so that indeed they can meet that 42-day deadline, which of course they are not under any obligation to stick to in total, because already we've seen some applications being brought in which were not in the original plan. This application for interrogatories, for instance, which there is an application for a review of. And of course, another thing that will happen during the pretrial hearings is that some of the mechanics of the witness questioning will be looked at. For instance, if a witness needs an interpreter, for instance, if there's a witness who, because of the COVID-19 and travel restrictions involved, is stuck in another jurisdiction, maybe they will need some technology to get that witness's testimony. All of those things will be worked out during the pretrial hearings. What we'll do right now is that we'll take a quick recap of what occurred in court yesterday, after which we'll come back. If the judges have resumed sitting, of course, we'll go to the Supreme Court. Otherwise, we'll definitely bring you some more analysis and some more insight into what to expect today. My name is Daniel Daze. Let's take a look at this.
Hearing comments with a request by lawyers for Mr. Mahama that some 12 questions should be answered by the Electoral Commission chairperson. The court, however, listened to legal arguments and came to the conclusion that it was not relevant. But first, we can take a listen to some of the arguments that were made in support of the request for those questions to be answered and the arguments against.
I refer to the broad scope of discovery because all those orders, further and better particulars, interrogatories, and so on, they are all intended to narrow down the issues for the trial and to make clear what really is in contention between the parties. That is what I wanted to emphasize. So what we have sought in these interrogatories, in our respectful submission, will achieve the objective of narrowing down the issues before this court.
Being sought are in the petitioner's own petition, the answer filed by the first respondent and also the answer filed by the second respondent. Questions being asked of us that where did the regional coalition center pop up from is all in the law. That is why we are saying that everything is in the law before this court. Now, my lords, we would also realize that the questions posed seek to introduce through the back door new facts which are not anywhere in the petition before this court.
A proposed interrogatory which does not relate to a matter mentioned in paragraph A of sub-rule 1 shall be disallowed, notwithstanding that it might be admissible in cross-examination. So it's a well-established rule of the common law that a matter that may be refused in interrogatories may be allowed during cross-examination. So our position is that all the issues that they are raising here, and if you look at the pleadings, are not in contention. They have been sufficiently answered. There may have been admissions which put them out of contention. And the petitioner may have his occasion during cross-examination to throw some of these questions at the EC.
Subsequent statutory amendments pointed out after 2013 have provided us with new procedural regime and strict timelines. We are strictly bound to comply with CR90 and therefore we will not apply Order 22 of CR 47 of 2004 in these circumstances. We accordingly refuse to grant the application and same is accordingly dismissed.
The court dismissed the application and lawyers for Mr. Mahama's team and the president's team have been reacting to the decision.
Indeed, just to let you know that we were ready and prepared with our issues because the last time the court directed that there was going to be a pre-trial, every lawyer knows that when the case is adjourned for pre-trial or case management, you have to prepare your issues. And if you bring an application to court, you either know that the application will be granted or dismissed. So there is no need to wait for that to happen. Much more so when you filed your application just about 2:40 p.m. yesterday. What did you expect? So yes, the application has been dismissed. Whatever they do afterwards is their own business.
Is your contention that
the real case in court has now started?
Is your contention that they are delaying the process? We heard your colleague make that point that he wanted to be dealt with.
Well, what else could be further from the truth?
We didn't need to even, I think that Ms. Jikata eloquently dealt with the issue of relevance, by, for instance, taking the court through, step by step, the relevance of each of the questions that we wanted the Electoral Commission, to answer. And then also, when Learned Counsel for the first respondent was on his feet, he himself pointed out quite clearly that the issues we raised were contained in their answer.
So hearing of the matter continues on Tuesday, and the main business of the day is first and foremost that the memorandum of issues are to be filed by the parties in the case. This is simply a detail of what the parties opt or hold a view to be critical to the determination of this particular dispute, and so they are going to propose the questions that they think the court should be asking them to provide evidence to support, and once the court adopts that, then the trial proceeds from there. Reporting for Joy News from the Supreme Court, my name is Joseph Akable.
Joseph Akable with the wrap of what happened yesterday. Let's go straight to the phone lines and speak with one of our correspondents who is monitoring events from outside the court, Kweku Asante, who joins us via telephone. Now, Kweku, you are outside the court currently. Tell us about the atmosphere.
Right. So actually today I've been in court, observing proceedings as they have come. And today the proceedings had just started a while ago before the court went on a short recess to do some matters. And normally, before I went inside, I was outside. What happened was we were expecting the arrival of the electoral commissioners as well as the petitioner, John Mahama. Today, John Mahama is not in court. He's being represented by the General Secretary of the NDC in the person of Johnson, Esidu Nketia. So when the court came in, they asked where the petitioner is, and Esidu Nketia stood up and said he was representing the petitioners. And so there were the lawyers for the petitioners, Chachu Chikata, Tony Lisa, were not all in their seats. And so the Chief Justice asked Mr. Esidu Nketia where their lawyers are, and then Esidu Nketia responded that the lawyers are in the registry filing some processes. So shortly after that, Mr. Chachu Chikata rushed in to the courtroom and actually told the court that the reason why he was not in his seat together with his colleagues were because they were in the registry filing some processes. And that is when Chachu Chikata announced to the court that they are filing for a review of the ruling of the court yesterday. And to remind viewers of what happened yesterday, the court ruled that Chachu Chikata's application to ask the Electoral Commission to answer some questions, which they say the interrogatories, which will, as it were, lead them to have some discovery and some information to narrow the trial, where it was rejected by the court, because certainly what the court was saying is that they've not showed relevancy of those questions and how they will help in the speedy determination of the trial. So that application yesterday was struck out and dismissed by the court. And so Chachu Chikata actually yesterday said that they wanted a certified true copy of the ruling to study and take some decisions thereof. And so I was not surprised when this morning Chachu announced to the court that, as it were, they are challenging the ruling. So we are expecting that shortly the court will come back. The court has risen. The court did not see the reason to look at the review. But what they said is that they are going to look at the processes that have been filed previously having to do with the determination of the matters. And so the court has just taken a short recess. It is expected to come back inside not so long, not shortly to proceed with the case. But what we expect is that just when the court comes in, the ruling, the review application would have been filed officially. Chachu Chikata, the counsel for the petitioners, will bring this up to the notice of the court, and then it will be argued. What we also know is that normally when a review is filed in court, additional judges will be added to the original panel so that they will hear the matter. And so there are currently 7 judges. And if this review application is considered by the court, 2 additional judges will be added to make the court 9 to just hear that particular review before the case will proceed.
That's a very interesting element that you introduced there, Kweku. The fact that some additional judges may be needed to review the motion, the application that was made, the application for review, I should say, that was done.
Daniel, what happens is, because these are the 7 judges that had the original application,
right? What
happens is, by a matter of law and by matter of fact, 2 additional judges would have to come on to complement those 2 judges so that a determination will be made as to whether or not the review being sought is valid or not. And when it comes to review, it is not up to the applicant to just make an re-argument of the case, as in say the same things they said that the court dismissed or accepted. So what they have to do is they have to show the court that the court erred in law by dismissing the motion that they filed, the application. And so the 2 additional judges will come in and then they would hear that. And so just after the court comes back from the recess, if the application for review has officially been filed and brought to the notice of the court, the Chief Justice, what we expect is that the court will take another recess again to reconstitute, put an additional 2 members on the court, 2 members of the Supreme Court on the court to make it 9, for the court to come again and hear arguments in favor of the ruling, and then a determination will be made thereof.
Kweku, thank you so much for bringing that to light. Let's go on the other line and speak with lawyer Samson Ladi Ayenini. And he, of course, is a private legal practitioner who has worked with the Supreme Court and has a lot of experience with some of these issues. So, Samson, with what you're hearing for the application for a review, what does it mean? Would the court have to reconstitute, add 2 additional judges to consider this application?
Okay, so there are there are 2 ways by which you can label the process as a review. What you may be very familiar with is the review that normally requires additional judges. There is the review that does not require additional judges. There is a review that by the civil procedure rules you apply for within 7 days after a decision has been given. And you apply to the same judge, same court. And there is no need for any additional judges to come on and to determine whether it should swing a different way or the other. So in the next few minutes, if they come back, we will get to know whether this is that type of review where there is a need for judges to be added onto the panel. But I am tempted to believe that this is not that kind of review. The law provides that when a decision is given in terms of a ruling is given by the court, and you take the view that something must have gone on wrong. Let me quickly, I was going to summarize this point, but let me read the law to you so that you know the kind of review I think they are doing. It says, a person who is aggrieved by a judgment or order from which an appeal is allowed, but from which no appeal has been preferred. Where you can appeal, but where appeal has not yet been preferred, you can take a couple of steps. And the step you take is that by a judgment or order from which no appeal is allowed, may upon the discovery of new and important matter or evidence which after exercise of due diligence was not within that person's knowledge or could not have been produced by that person at the time when the judgment was given or the order was made on account of some mistake or error apparent on the face of the record or for any other sufficient reason, apply for a review of the judgment or order. Judges are human beings. They can take a certain decision, and the decision may be taken in a rush. It may be taken on the spot, and they may have, not paid attention to a particular rule, a particular precedent, or something of the sort, or some evidence, or something apparent. You bring it to their attention, and they will do a review and give you a different decision. Or they may still say the old decision they gave will stand. So there is a review that is done in that sense. So if I went to court today, I moved the motion, and I did one not too long ago. I did a motion, and the judge disagreed. Then within 2 days, I took a motion back asking for a review to the same court, to the same judge. And that same judge reversed her own decision she had given 2 days earlier because I had brought to her attention a law that she didn't pay attention to the first time. So it's allowed. So I suspect this is that kind where you don't need extra judges to be brought on. But let's wait. In a few minutes, we'll get to know.
Yes, indeed. In a few minutes, I can't wait to see which mode that they would employ myself. But what does this mean, Samson, if these interrogatories are finally accepted by the court? How does that change the flow of the court's proceedings as was earlier determined?
If the interrogatories are allowed, I can only say what I have heard the lawyers prosecuting the case to contend. That, today they are supposed to submit their memorandum of issues by 9 o'clock before the court will sit.
Yeah.
And I heard you speak about that.
Yeah.
So I had heard one of the lawyers say, or Chachu himself, when the question was posed to him yesterday, that yesterday was for the issues. And he said he needed up to Thursday. He tried to suggest that the interrogatories, if they had been allowed and they were answered, may have changed the issues or the manner in which he will frame the issues for the court. And that is the reason when my good friend Akoto Ampah suggested that they were there yesterday for that, so he should not be heard to suggest that he wasn't ready. Then you heard him say, it's not really exactly that he's not ready, but if the interrogatories were allowed and the electoral commissioner answers, commission chairperson answers them, it may have influenced the issues that he will bring forward. So that's really about it. So if it's allowed, they sit again and listen to it and allow it, and the EC is allowed to answer those questions. If she answers them, it may influence how the issues are framed. But in the absence of that, the issues for the court will still be framed. The issues, the memorandum of issues, is a very simple thing. You see, both of them have documents, papers put before the court containing several paragraphs and pages of what is known as pleading, or if you like, allegations and counter-allegations of stuff. The court cannot sit and say, we are going to decide from paragraph 1, paragraph 2, paragraph 3. No, you don't do that.
Okay.
So the issues are actually the time when the court works together with the parties and the lawyers to narrow the issues down. The whole suit now will come to maybe 1 or 2 issues, which will engage the attention of the court for the entire trial. So if you remember, in 2013, the lawyers could not agree on the issues, the memorandum of issues. Normally, we agree on these when we are going to the Supreme Court. We agree on them together as lawyers. And we say, okay, I think the germane issues in controversy are 1, 2, 3, which we should let the court deal with. Then my friend on the other side will say, you have 3, I have 4. The 4 I have, I think you have 1 or 2 that are similar or of the same as what I have. So let's reframe them to capture what we both want. Let's do away with issue 2 or 3. Then in the end, we are left with only 2 issues or only 3 issues. When we can agree that way, we do it among ourselves and we just submit the memorandum of issues to the court.
Okay.
But when we cannot agree, and in this circumstance, the court has asked them to bring them. So what it means is that they may not have the opportunity this morning to look at what everybody has filed and to agree. So once you file them, the law says the judges must take control and help the lawyers to now, tweak the issues.
Okay.
They can look at the issues you would find. And very soon, I'm sure we'll see. You'll find that maybe almost all of them have framed one particular issue, but the wording may be different. Then the judges will help them to frame it in a way that captures everybody's way of looking at it.
Okay.
Then somebody may have up to 5 issues or more, and then the judges will say, we can combine this person's issue 1, this person's issue 3, this person's issue 4, and then when we combine it, we can get one issue out of that to stand for everything. Then when they finish, they would have narrowed things down to about 2 or 3. In 2016, 2013, I think one of them had as many as 11 or so issues. But they ended up narrowing everything down to only 2. So the court, in the trial, the focus will be on answering those 2 as the ultimate for the trial. So they could frame the issue, number 1, whether or not, and is a legal terminology that Justice Aniyabua, who is the CJ now, taught us not to be doing whether or not. We can actually say whether and not saying or not, and we'll be fine. So some are flexible. So they could say whether the first respondent, whether the petitioner and the second respondent garnered enough votes to make more than 50%, to make the more than 50% threshold in the 2020 election.
Okay.
And that will be narrowed. Once that is narrowed, that will engage their attention. All who come to the court and do business, you must be working towards answering the question whether or not both candidates made more than 50% of the total vote.
Okay.
Valid vote.
That's
they
very
can frame another issue whether or not by failing to follow certain procedure, the election should be annulled, or whether there should be a rerun. They will do it that way. You'll see it very shortly.
Great. I'm very curious to hear the fact that these interrogatories could actually affect the issues that the petitioners' lawyers would want to present. And I remember very well when Joseph Akable was asking that question of Dominic Ayine yesterday, he asked whether or not if I can borrow your expression, whether the ruling by the Supreme Court yesterday could affect the way they would do their business going forward. He said yes, it could, which makes that suggestion. But this is the case, Samson, where Mr. Chikata mentioned earlier when he went to court today that they just filed their memorandum of issues. Can they still change their issues even though they filed them already after these interrogatories have been done?
Yes, we are allowed to do what is known as additional issues. The law allows us to do what is known as additional issues. So if it is granted right now, they could actually take a determination that they are settling on the issues for now, and that by the time the questions are answered and so on, subject to that, they could bring 1 or 2 more issues for consideration. It could also be possible that the court could say they will do that now, and that whatever answers are received, they are not going to receive any further issues. Because they have a way of looking at it where they could say that because they may have anticipated certain answers, they are able to do what may be called the omnibus issue. Then the omnibus issue is normally framed as this: any other issues arising out of the pleading or something to that effect.
Okay.
So they could do an omnibus issue, but in the Supreme Court, they hardly will allow such a thing. But depending on the circumstance, they could do so that it will take care of anything that may come after the meeting today. But like you said earlier, you see, the part of the thing is they are going to do the case management. And in the case management, everybody will know who they are going to call to be their witnesses. Right. And then they will be ordered to file what is known as witness statements. Previously, we used to put your witness on the witness box, and then they will do examination in chief, which takes too much time. But we have changed that law for a while now, where you don't do examination in chief. You simply have anything you will say put on paper, and then we just come and do cross-examination. So it shortens the process.
Now, the justices took a recess so that they can consider the documents that were filed this morning. Should I take it then that it's possible Mr. Chikata missed the deadline for filing of issues? Because yesterday we heard that it was supposed to be done by 9:30 a.m. this morning. Yeah. Will his failure to meet that deadline have any implications?
No, it's not fatal. It's not fatal.
Okay.
Yeah, it's not fatal. What it actually meant was that the registry of the court would have been open before the 9 a.m. and it's often open around. By 8, you can start doing business in the registry. So if they didn't file it yesterday evening and they didn't file it early enough this morning, it will be accepted. And then right now, they will be studying them. They may actually come out and say that we have seen your review application, we have seen we are not going to hear any argument. We have heard enough. We have seen enough on the paper. We are making a decision. Your review application is granted or it's refused. Let's go to this. Let's go to that. Anything is possible, except that they may also take a decision that once the other parties involved may want to also say something about the review application, then they should be given opportunity, maybe today, by close of day, to also file their opposition to what has been filed by Mr. Chikata as regards the review application. But I understand that they have actually also filed to discover some documents. So there's actually a process for discovery of documents, a fresh one.
Yes, that is also another issue that I wanted to come to, Samson, because apart from the application for the interrogatories yesterday, there was also some facts that they wanted to set out, some 19 facts. How do those come into play? Is it not the case that, for instance, you can go to court and begin asking your questions for those facts to be laid bare?
So the interrogatory in our rules, and the Supreme Court is not set up as a trial court. So they don't do trials, except that in this circumstance, they do a trial in a presidential election. So their rules don't include trial rules or trial procedure. It is the reason we have had to carve out of their rules. Their rules are CI 16. It is the reason we have had to carve out of their CI 16 CI 74, which we use for the 2012 election. Then election petition. And then, which has also now been improved by an amendment number 2, which is CI 99.
Do you mean CI 47 and CI 99?
No, CI 74. CI 47 governs what happens in the High Court. And the High Court are trial courts. That's where we put people in the box and we talk and cross-examine and do things. The Supreme Court largely does what you call the appellate jurisdiction. If things don't go well down there, then you go up, and then you end up at the Supreme Court. They normally will do a case without putting anybody in the witness box. They normally will do a case with lawyers writing legal arguments. That's it. And then they engage the lawyers, and then they give a ruling, even though they have what is also known as the original jurisdiction. But even in the original jurisdiction, when they are doing a case, people don't get into the witness box. So there's a small departure where the law says when it comes to presidential election petitions, they must do the trial. But in the procedure that governs what they do, it does not make provision for procedure for trial. That's why we have to now bring in a CI 74, not 47. 47 is for High Court. We have a trial procedure also for Circuit Court and District Court. Circuit Court can actually use also what we use in the High Court. Then we have one for the Court of Appeal rules. They too, they don't do trials, and there are rules how they do their things. Then in the Supreme Court, they too have the rules, and which is what, because we have distinctly said they should try a presidential petition, we now have to make room for rules for trial. It is the reason in the 2013 election petition, you realize that they said that where their rules don't make provision for certain things, they will fall on the High Court rules, which is 47.
Oh.
So 74 was not sufficient. It's the same vein, 99, CI 99, which is the current one, which was done in the 2016. It's also not sufficient because it doesn't have rules on interrogatories and all the things we do in discovery. But you will use that. In fact, most of the things they are going to do now, like witness statements, you don't find them in Supreme Court rules. You find them in trial court rules. So they will use the rules of the High Court regarding witness statements.
So is this why yesterday we heard Mr. Chikata refer to CI 47, and I think I caught him say there that CI 99 does not cover some of the processes that they are pursuing in this particular case?
Yes, and for very good reason. There's actually no need for CI 99 to cover those things because the court is allowed to use the CI 47 to take care of a trial.
Okay.
Do you understand?
Okay.
So that is actually a procedure and standard that is a given. We all know as lawyers and as practitioners, we know.
Samson, hold on just a moment for me. I will come back to you because this is so key what we are doing now. But I quickly want to introduce Winston Amwa into the conversation, Deputy Head of our political desk. Winston, yesterday one of the key arguments was that the petitioners team, that is the team led by Chachu Chikata representing John Mahama, is simply trying to delay the case. Of course, this was denied vehemently by them. They said they actually want to expedite the case going forward. What do you make of this new introduction with the application for review?
Well, Daniel, you know, under the circumstances, what I make of it would not really matter because the court will decide, and we're told that will be happening on Thursday for the review. So my initial comments would be, let's just adopt a wait-and-see attitude and see what will be the determination of the court, Daniel.
Yes, very important, of course, especially when we are looking at a case as sensitive as an election petition where, you know, the political atmosphere is quite polarized. This morning we've been discussing the president's appointments, and even though that should normally not be affected by what happens in court, the international community, everyone will have their eyes on this, will they not?
Exactly, and you know, we've been having these discussions, but then also what we are mindful of is that lots of the decisions that we're awaiting will be taken by the court. And so the court gets to decide whether or not we'll be deciding the memorandum of issues. The courts will be deciding when the NDC moves for its review on Thursday, that's tomorrow. The court will decide whether or not to grant that review. What we do know now, what we can talk about, is the court not granting the interrogatories, the 12 of them. That's the John Mahama team, or the petitioners. Let me put it that way. Let me use the right term. The petitioners sought, and that's the most important now. While we wait the decision on other issues.
Right, Winston. I'm still gonna come back to you. Just give me a moment. I just want to get a quick word from Samson on you're introducing to a lot of us, really, Samson, what happened and why CI 99 may not be sufficient, why CI 47 would be used. But I remember clearly, though, that the Supreme Court justices, in delivering their ruling yesterday, did mention that some of these things are catered for. They relied on CI 99 really to make their decision. And this is the case where CI 99 may not cover some of the processes that Mr. Chikata was talking about. Could this be something that they could reconsider to affect the decision that they made, without, of course, prejudicing what they will say when they come back?
If you read the decision they gave yesterday, they didn't say that CI 47 does not apply in the Supreme Court. The political party people communicating it have been misleading everybody. And they have been deliberate about it. I'm sure they know very clearly. Because if you read it, you hear them say that in this circumstance, and on this issue, in the present circumstance, they do not intend to apply CI 47. They didn't say CI 47 does not apply in the Supreme Court. They didn't say that. So if they said CI 47, they would not say that. In fact, I dare say they cannot say that because they do not do trial. And anytime they need to do a trial, they will require to fall on CI 47. Like I told you, they are going to be asking them to do witness statement. Witness statement is not covered by Supreme Court rules. It's not covered by whatever it is. And normally, the small amendments they make doesn't cover enough. And it's not about not covering enough. It's about the fact that the thing is already there. There's no need to do a new one for it. So they understand that things will happen, that CI 47 will be applied for that process. Therefore, we don't need to go and reinvent the wheel. So they said for yesterday's circumstance and for certain expedition they are looking for, they do not, for that moment, want to apply CI 47. And they gave a good reason. Now, today, actually, the issues, they are likely to set down some two issues which they would determine, they would ask the people, the parties to, the lawyers to write arguments about and file, which may be determined without witness statements being filed, without cross-examination happening, and it can terminate the entire case. That is possible today. I mean, today, not to determine that today, but to make through part of the case management to say that the second respondent, Nana Akufo-Addo, has set down some two issues. And those two issues are premised on the preliminary legal objection that they raised in their answer. You know, both first respondent and second respondent have raised preliminary legal objections.
Yeah.
And preliminary legal objections in law must naturally be determined before the substantive matter. Preliminary legal objections often will not determine the merit of the case, and therefore they may not even become, it may not even become necessary to call anybody to come and stand in any box and say anything. Lawyers will just file arguments, and on that basis, it may be determined that the case does not, the petition does not disclose a reasonable course of action, and on the basis that it does not disclose a reasonable course of action, it is frivolous, it's unmeritorious, it's thrown out. So that is also possible. They can determine that they will do that today. You get that?
Right.
And once again, you see all of these things. It is CI 47 process that we use to follow them, and the general common law that we use to follow them.
So the application that was the decision that was made yesterday was very specific, that they had chosen not to apply CI 47 in the specific ruling which they made yesterday.
They were very clear, and I could actually read that particular sentence to you because they were very clear about it. They said, and I'll read it here. They said that indeed, Rule 69C4 of the Supreme Court Amendment Rule CI 99 directs the expeditious disposal of the petition and set timelines for the court to dispose of the petition. It implies that even amendments ought not be sought and granted, as well as joinder of parties. There's an issue there where they say blanket that even amendments ought not be allowed. The law doesn't say that. The law actually says amendments that will alter the grounds of the petition or will add on to the grounds of the petition is what is not allowed, not amendment simpliciter. So they go to say that subsequent statutory amendments pointed out after 2013 have provided us with new procedural regime and strict timelines. We are bound to comply with CI 99, and therefore we will not apply Order 22 of CI 74, CI 47 of 2004 in this circumstance. We will not apply it in this circumstance. So if you read it that way, you will know that they haven't said that CI 47 will not be applied or used by the court. They didn't say that. They said in this circumstance. And on the basis of CI 99, giving timelines and for expedition and everything else, they took the view that for yesterday's issue, they don't want to do it. They have come for discovery. Discovery is not provided by CI 99, but it's allowed in law. So let's hear what they will come out to say about the discoveries they are seeking to do also, because that will be guided by CI 47, because CI 99 does not provide for them. And I go back to that point that you don't actually need CI 99 to provide for everything, because we already have the rules there. So we don't need to waste our time copying the rules from another provision or book, which we are allowed to use onto a new book. Exactly.
Let me quickly bring Winston in on this. We also saw a request for facts. Some facts which would be very key to the case. I saw one of them, of course, being the famous 100.3% that some communicators of the NDC have pointed at repeatedly. How important do you believe this leg of the entire conversation is? Is it not the case that we are beginning to see more of the issues being laid to bear, Winston? Right, please unmute your microphone, Winston.
Yes, if you could repeat the question again, I didn't get it clearly.
Yes, I was pointing at some of the issues that are being raised in a request for facts by Mr. Chikata and his team. For instance, this issue having to do with the percentages adding up to 100.3%. This issue having to do with the figures read out on the 9th of December, which differed if you looked at points 5 and points 9 of that document that was filed yesterday. This really brings some more clarity to the issues that Mr. Mahama and his team want pointed out, does it not?
It does, and I mean, right from the start, you would have seen that in the relief that the NDC was seeking, they had made these points clear. They talked about the declaration on the 9th, and you had heard Mr. Chikata argue the importance of a declaration, and the fact that they believe that the press release that went out on the 10th of December did not amount to a declaration. The thing about these issues, again, and I'll get back to it, is that, look, this would form the basis of the NDC's case. The fact that what we saw on the 9th is what actually amounts to the declaration. And that is why you've seen the Electoral Commission in the memorandum of issues that they would want to consider. That's the first respondent. They're talking about the fact that does this affect the numbers? And does also the allegation of vote padding affect the outcome of the elections? They're trying to send a signal to you that, all that you're talking about, does it really affect what the people or how the people voted on December 7th by way of the numbers? And these are the issues that, the Supreme Court, again, would have to look at. And they would have to look at it because they have the right to do so. They have to look at it. Of course, the NDC, or the petitioners will make their case, and then the respondents would also make their case. At the end of it all, after the 42 days, we would know whether or not, the Supreme Court agrees with the petitioners or it agrees with the respondents, Daniel.
And that's the expectation, that it takes 42 days. But Samson, it's beginning to look like it could go beyond 42 days. Of course, there are lawyers who argue that the Supreme Court is well within its rights to extend the time beyond the 10th of February. Is that not the case?
Okay, so once again, that will take us to CI 47. Because CI 99 sort of cast the time in stone. But, you know, the general rule allows that while there's time for delivery of judgment, for good reason, you are allowed to exceed the time. But again, the court has a certain inherent power and a discretion to exercise. So the timeline will only serve as a guide. It does look to me that they may not be able to comply with the timeline, to stick to the timeline. But if you read what they say themselves, it looks like they still want to stick to the timeline. Because the very last paragraph, the last but one paragraph of the ruling yesterday, they said, we are strictly bound to comply with CI 99. Strictly bound to comply. And before that, they had also pointed to the fact that they want to keep to the new procedural regime and strict timeline. So maybe, just maybe, they will, but it doesn't look possible. And if it doesn't look possible, they are allowed to abridge, extend the time in the same way they are allowed to abridge the time and bring things forward. So, the points
it's definitely going to be another interesting couple of days coming up. I'm curious about the preliminary legal objections that have been raised and what that would mean for the legal process, but I'll come to you quickly for that. Winston, this issue of time, we know that even the decision to hold this entire process in 42 days was opposed by some assignments of the NDC ahead of the process, including questions about the selection of the panel by the Supreme Court judge, by the Chief Justice, and of course, the composition issues. The conversations around this and the sense of trust that we must have in the judiciary, what would these decisions mean for that general situation, Winston?
You know what, Daniel, yes, I've heard Dr. Basit Bamba raise concerns about the composition of the panel. I haven't heard in the court, concerns being raised about the composition of the panel. And, in 2013, during the election petition, the NPP had indicated, the petitioners had indicated they were going to, raise concerns about the president of the panel at the time, because of his relationship to then President's executive secretary. But we all saw how, Justice Atuguba conducted the whole process. So there are some of these indicators that may come up out of the court itself. I do not think that anybody who doubts the judiciary will take a case to the judiciary to adjudicate on. And so that will be an indication of a trust in the judiciary. And for me, as the one who believes in the rule of law, I do not think that anybody who believes in the rule of law must trust judges. If you do so, you don't take your cases to them. So I do not think that the petitioners doubt the judges. It is a reason why they're continuing the case.
Yes, of course, but there were obvious questions from some members of the NDC that at the time to consider this case would be too short. Would they be vindicated if what Samson suspects is true and this entire process delays beyond the 42 days?
I can't hear you, then if you could speak up for me.
Pardon me, I hope you can hear me better now.
Yes, I can hear you now.
I was saying that with this issue of 42 days, the possibility that the court proceedings could extend beyond that, would they then stand as sort of a vindication of the arguments that the NDC put ahead of this, that period itself was too short?
Well, I mean, there's a hypothetical situation, and let's see what happens. We've just started. There's a time for. I mean, we have a lot of the number of days has a lot of time dedicated to the ruling. I don't know if the judges would look at it and say, we'll give you some more time so that we reduce the number of days that we have to, write our rulings or bring out the verdict. But it's just the, third or fourth day in court. It's still early days. And it's important we look at what the coming days would bring. And it's only then that we can, say we may not be able to do this in 42 days. And that's, it's a vindication that the number of days were not enough.
Now, Samson, I remember we had a conversation about this on Prime Morning, and the example of Kenya was given where a Kenya election petition is done in 14 days. Your proposal, which you shared with us so graciously, was that this be done in 80 days. But I do get the feeling that no amount of time would have the majority of lawyers in the country agree that it was enough, as long as there's a time limit on this entire process.
There's a time that is reasonable. And today, as we speak, Daniel, if you count from the date when the petition was served, then it means we are on the day that the trial should have concluded. Today is the 21st day. So today is when the trial should have concluded. So we have already reached the time. The time given in the law is that, in CI 99, is that from the 15th day, we will start the trial and it will end on the 21st day. Today is the 21st day. So that's what I'm saying. There's flexibility. It's allowed. And from where I sit, where I had the privilege of being contracted as a consultant for the Judicial Service to assist in seeking solutions after the CI 74 didn't produce the expedition that we were expecting. In CI 74, the timelines have been provided for everything except for the trial. So when it gets to the trial, the CI 74 said that the trial shall be expeditiously. And I keep saying expeditiously saw us doing 8 long months. We actually did more than 8 months. Now, when I had the opportunity to now help in the process of finding a solution, and before most of the Supreme Court judges, when I did a presentation, and I used the Kenyan example. Kenya, you filed the petition within 7 days after the declaration of results, and then the petition is heard within 14 days. Now, I carefully studied the Kenyan process and how the judgment was rendered. In Kenya, it's in the Constitution, it's not in rules. It's in Constitution. And I discovered that the 14 days constricted the judges and did not allow opportunity for certain things to be done. Because, like they say, justice delayed may be justice denied, but justice rushed, okay? When it is hasty, may also not be the best. So I made a presentation and I suggested that looking at what Kenya did and looking at what we did, we should do 80 days. Then, in fact, when I was done, one of them approached me and said, why don't we look at about 100 days? And I said, 80 days should be sufficient. Now, as a consultant, you are done with your job. They decide how they go about it. They look at it and they did with the timelines and came to the conclusion that if they cut down on certain things, and you see in the new rules, they have cut down on a number of things. No jointers, amendments, strictly speaking, not allowed, and so on and so forth. So they set the timeline, and I agreed with the timeline that it was good, it was possible to do it within 42 days. But here we are. We have already gone beyond the time. Today, we should have been concluding the entire trial. We are not there. So, look, it is the reason the rules and the general principles allow for flexibility and for reasonableness in how things ought to be done.
Very important points there.
They are clearly in control.
I just wanted to draw our attention to what we are just picking from courts, that the NDC review, the application for review, is not what is being considered now. Currently, they are considering the memorandum of issues, but the review date is Thursday, which is tomorrow. So the entire issue about interrogatories and what have you will be separate from the issues which are being considered by the justices of the Supreme Court. That should then mean that when they come back, we should be seeing us go straight into the pre-trial issues, are we not, Samson?
That's it. So when they come back, once you settle on the memorandum of issues, then the door is now open, or the way is now open for directions. And the directions will be what they will say. You are calling 2 witnesses, 3 witnesses. Okay, great. What is this witness about? Maybe you are calling some accountant. You know, the NDC, John Mahama clearly would have needed somebody to work the numbers, to come to the conclusions that they have. And he may feel that he needs such a person to testify for him on the numbers, and to get to a conclusion where you can say that the error spoken about actually led to a certain, defect. So they may say we are bringing in an accountant or some expert of sort. Then it's okay, you bring a witness statement for that person, and so on. Documents that you need to also rely on, you bring all of them together or attach them to your witness statement and then submit them. We give you 2 days each to prepare your witness statement and bring them all together. Or this person prepare yours first. Once you give it to the other party, then they too have 2 days to bring theirs. But in this case, I can predict that they will say, all of you bring it at the same time, simultaneously, and number them this way or that way. And then once you bring it, we will set out 1 day on which we will go through all your documents, confirm that what the petitioner has, respondents all have them, and the court has everything intact. And then they could set and say, you have 3 days for your cross-examination. You too, you have 2 days for your cross-examination. You too, you have a day for your cross-examination. Depending on people's needs, then they would, each particular lawyer's needs, they would seek to circumscribe, because you are working with time. When we come, we can use the whole day. You will use 1 hour for your cross-examination, and you too, you will use the 30 minutes for your cross-examination. They will deal with all of that. So, we can expect that once they settle the issues, this is the next thing that will follow. But like I hinted, that the respondents both have raised preliminary legal objections. CI 99 says you can raise your preliminary legal objections in your answer, and then later you will file arguments. I suspect that because of the first 2 issues that the second respondent has set down, we have seen the memorandum of issues by the second respondent. If you look at them, the first 2 clearly are about their preliminary legal objection, and I suspect the first respondent will do a similar thing, and then they will make a prayer to the court that the question of the preliminary legal objection should be tabled. Now, if they go into that and they are successful, case has ended. You don't need 42 days for anything. They could say they should file their argument within 2 days and come by, say, Monday for the ruling on the preliminary legal matter. And so it could be possible that by Monday the case will be ended.
Interesting. What are these first 2 issues, for the sake of our viewers, and what makes them so paramount to the case itself?
Right. So the law requires that you hint at the fact that you intend to do something. And they have hinted, the 2 of them have hinted in their answer. Then it says then there will be arguments to be filed. So, President Akufo-Addo's issue 1 is that whether or not the petition is incompetent, and discloses no reasonable course of action in terms of Article 64(1) of the Constitution 1992. This encapsulates the paragraphs that they have, deposed to, saying that the case is incompetent. And they say it's incompetent on the basis that it discloses no reasonable course of action. So they have made that an issue number 1. And I suspect because the Electoral Commission also raised similar and same preliminary legal objections, they will also bring an issue like this. And then they will ask the court that set this issue down for trial first. Because when the issue is determined, it can terminate the whole proceeding. And the law says when there's a preliminary legal objection, that goes to the heart of the case. You take it first. Because by taking it first, you may save all of us time. Their second issue is whether or not the errors and alleged both parties complained of by the petitioner, granted same to be true, affect the outcome of the presidential election held on 7th December 2020. That brings you to the issue Winston has been, talking about. Presidential election petition, or to be more specific, election petition. The bottom line will normally be whether the number of votes we are seeking to strike out are substantial enough to overturn the victor's, position, the victor that you impugn his position. So in 2013, if you read the judgment of the court, you will find that Justice Eniebua, who is now presiding, in 2013, he actually struck out some of the votes. Bafuboni, yes, I think I'm right about it. Bafuboni also sought to strike out some of the votes.
Samson, so we will come back and deal with this issue now, but the justices have resumed their seat and they are currently speaking. So let's go to the court.
Petition discloses any reasonable course of action. 2, whether or not, based on the data contained in the declaration of the first respondent and the second respondent as president-elect, no candidate obtained more than 50% of their valid votes cast as required by Article 63, Clause 3 of the 1992 Constitution. 3, whether or not the second respondent still met the Article 63, Clause 3 of the 1992 Constitution threshold by the exclusion or inclusion of the Techiman-South constituency presidential election results. 4, whether or not the declaration by the first respondent dated the 9th of December 2020 of the result of the presidential election conducted on the 7th December 2020 was in violation of Article 63, Clause 3 of the 1992 Constitution. 5, whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. By virtue of the powers vested in this court under Rule 5, Sub-Rule 4 of CR 99 to dispose of this petition within strict timelines, the following orders are made accordingly. 1, mode of trial. The petitioner and the witnesses shall file witness statements with exhibits, if any, by noon of Thursday, the 21st of January 2021. 2, the witness statements shall be served on the counsel for the respondents by the close of the day of Thursday, the 21st of January 2021. 3, the respondents and their witnesses, if any, shall file their witness statements with exhibits, if any, by the close of the day on 22nd January 2021. 4, the first and second respondents shall file their submissions on the preliminary objections raised to the petition by 12 noon on Friday, the 22nd of January 2021. 4b, the registrar shall ensure service of the submissions of the preliminary objections by the close of the day on Friday, the 22nd of January 2021. C, the petitioner shall file any response to the submission of the perennial objection by noon on Monday, the 25th of January 2021. D, the registrar shall ensure service of the petitioner's response by the close of the day on Monday, the 25th of January 2021. E, ruling on the perennial objection will be incorporated in the judgment of the court. Timelines. The court shall sit on Tuesday, the 26th of January 2021 for hearing of this petition.
My lords, we have just heard the orders that you have made. We thought that part of the hearing this morning was in effect to enable us to make representations on the various things, but it looks like your lordships have made certain orders, and there is some degree of unclarity, at least in our minds, as regards what is referred to as a preliminary objection. Because, my lords, there are, in the two answers, there are a number of different things that are referred to. I'm actually not clear.
Of the preliminary objection. The issue to be determined as preliminary objection. That has been set out as read by the President of the court.
Well, perhaps we could hear it again, because it was not...
Is whether or not the petition discloses any reasonable course of action. That's it. Yeah, please, we will instruct the registrar to type the orders by the close of the day, and they will be served on you. Because it's case management, you have to be fully informed of the orders.
My Lord, with respect, it is case management, and I believe we have an input that we can also make as parties, because we had, for instance, witness statements, is it by tomorrow? I mean, my Lord, with the greatest respect, I mean, we are human. I mean, maybe they're superhumans, you know, but we have filed this morning, as of this morning, we have filed an application for review of a ruling that you delivered yesterday. There are consequences to that. We also have outstanding requests to admit facts, which are due within 3 days from when they were served on the other party. There are a number of outstanding issues which have not been discussed.
Mr. Jigata, there's no outstanding issue. The application for review of our ruling yesterday does not operate as a stay of execution.
Well, I did not, with respect,
we are operating on strict timelines under CI 99.
And add the notice to admit.
Yes, but my Lord, it can affect the issues. In fact, your lordships will recall that yesterday, when we were discussing the filing of the issues, we raised the point that the matter of the interrogatories and the notice to admit facts could affect the issues that we filed. There are some issues that we may not actually require.
Mr. Chikata, if you get there, can't you apply for these issues to be taken as an additional issues?
Yes, but in the meantime, we'd have filed witness statements, yes, which are limited to...
You are call 5 witnesses. I believe you should know what they are coming to say. As at the time you were indicating that you were going to call 5 witnesses.
Yes, so we are going to have 1 day within which to supply witness statements in respect of 5 witnesses. Is that? I think that I think that with respect is not fair to us, because with the greatest respect, we have indicated that we have 5 witnesses. We may end up not calling all 5 witnesses. But in any case, we have now, today, until tomorrow, in order to prepare witness statements.
Mr. Jikata, this should have been prepared already. No. Well, these statements should have been prepared already.
Well, that is not correct. maybe your lordships,
Mr. Jikata, excuse me. Mr. Yene, please, please resume your seat, sir. Please, you are a senior member of the court. When the bench engages counsel, you don't sit down and make gestures as if you are part of the legal team. I've been watching you. Please, this is not fair. You see, the other time we heard you clear when an objection was taken, when the representations were announced. I even asked Mr. Chikata whether they were limiting themselves to the only 2 counsel. Mr. Chikata, I think you remember the very day, and you said you were with only Mr. Luther. And you were recorded as such. But Mr. Ayine, please, out of respect for you, please don't do that again.
Mr. Chikata, if you recall, we've gone through the regimes of CI 87, we've gone through the regimes of even witness statements in criminal matters, and so where we've arrived at now in administration of justice and case management is preparing everything up front, and I'm sure you are quite aware of that.
I'm aware also of the fact that it is a matter which parties may make representations about. That is a matter of whether it is conducted through witness statements or through oral testimony. I mean, that is also a matter to be considered on the basis of representations made. But, I mean, your lordships have made the orders already, and we will be served with them, and I believe we will advise ourselves. But I do feel obliged to indicate that the timeline that is provided for us to have witness statements, does not seem to be justified.
But Mr. Chikata, you know about CI 99 and its schedule. That's the 2016 law.
I do know about the schedule provided, but I also know that your lordships are here to administer justice, and that justice must not be sacrificed for expedition.
The petition is hereby adjourned to Tuesday, the 26th of January 2021 for hearing.
We are grateful to the court. Please, resume your seat, please.
Lords, we are most grateful.
All rise.
You're live on the Joy News channel, and what we just witnessed was an exchange between Chachu Chikata Representative John Dramani Mahama and justices of the Supreme Court, especially after the justice of the Supreme Court read their orders after considering the memorandum of issues. Let me quickly go on the phone lines and begin speaking to Samson Ladi. Samson, in simple terms, what just happened?
Yes, what just happened is what I told you, that they are allowed by law to receive the memorandum of issues and to go ahead and, as it were, tweak them. And you have seen what they have done. They have tweaked the memorandum of issues. I think in this case, they've even had too many issues, up to about 5 to 6 issues or so. My expectation was naturally that, they would have narrowed to even maybe 3 at most. But clearly, there will be good wisdom and justification for the 5 or so issues that they have set down. Now, once they set down the issues, remember what I told you earlier too, they have gone ahead to also give the roadmap, filing of witness statements and the documents to be relied on, and then returned to the court by the 26th. Of course, the preliminary legal objection. They have used, I think, issue 1. They have set issue 1 down for argument, legal argument, for that to be determined. Except that instead of determining it before they do the whole case, they have decided that they will do the whole trial, finish, and give their reasons, whether they are upholding the preliminary legal objection or they are rejecting it in the judgment itself. So they will incorporate their decision as to whether they accept the fact that the allegation that there is no reasonable cause of action, it's incompetent, and so it should be thrown out, and they should not be heard at all on the merit. Whether they accept it or they reject it, they will also put that in the judgment itself. So while they are going, the first thing they are supposed to pay attention to, it looks like the legal teams have to divide themselves properly. One group may work on the witness statement, and another group may also work on the written response to the preliminary legal objection. Now, those who have raised the preliminary legal objection would already have prepared their argument somewhat. By now, everybody and their practice. But if I raise the preliminary legal objection, it simply means that I have prepared my facts, I have prepared my law that I'm going to rely on. So for them, it is easy for them to go and write their argument. But as a lawyer also, when somebody raises preliminary legal objection and brings it to my attention, I will also immediately start preparing how to answer it. So it is also possible that Chikata's team also may have done some preparatory work to answer those preliminary legal objections. So they've been giving up to close of Friday to file those things. So let's see how it goes. And then by Tuesday, the 26th of January, they return for trial to begin. That looks to me, yes, actually the objections, they are filing everything by Monday, the 25th.
And then trial begins on Tuesday. But in the meantime, that application for review will be considered tomorrow.
That's right. That's right. That's right.
Okay.
You heard Justice Samuel Marcusau say what I told you earlier, that yes, we can go ahead, and then when we make a determination on your interrogatories and things, you can file additional issues. Right. It's allowed in law. These things are very common, everyday practice things that if you're a lawyer in practice, not a lawyer in theory who is not in practice, you come across them every day. If you are asleep and they wake you up, you can talk about them with precision. So, except that it's an election petition, so sometimes the way the communication is done in a way with tensions and all of that. I think the people who are communicating can do the whole country a favor by communicating these issues as lawyers, particularly those who have practice experience.
Okay.
Those who are communicating, if you look at the list, some of them have practice experience. For those who don't have practice experience, you may indulge them. But those who have practice experience, they should tone this thing down today, nobody won anything, nobody lost anything. The court did something that will ensure expedition. And what they did, they are allowed in law to do. Let nobody be heard to say, oh, they stampeded somebody, they didn't do anything, they didn't do things according to. Yes, when we are doing these things, lawyers and parties are allowed to contribute sometimes.